AP Dover Delaware attorneys for the U.S. bankruptcy trustee in Delaware, as well as representatives of numerous significant media outlets, are contesting an attempt by cryptocurrency exchange FTX to keep the identities of its clients and creditors from the general public. The court overseeing the FTX bankruptcy granted a motion by media outlets to intervene in order to contest the sealing of creditor information at a brief hearing on Friday. Judge John Dorsey postponed a separate objection by the U.S. trustee, the government watchdog that monitors Chapter 11 reorganizations, until January 11, when he most likely would also hear arguments from the media.Juliet Sarkessian said that the debtors simply cannot claim bankruptcy protection and then do business behind a veil of secrecy. Allowing FTX to conceal creditor lists and financial schedules would be a slippery slope, according to Sarkessian, and set a bad precedent for bankruptcies where creditors are also clients. Even though customer and creditor names and addresses are normally made public in court documents, Dorsey last month temporarily agreed to FTX's request to redact them. The judge did order FTX to submit an unredacted creditor matrix to the court under seal, but the business has not yet done so. FTX has also attempted to hide the identities and addresses of non-customer individual creditors who are residents of the United Kingdom or other EU countries, invoking the GDPR, a consumer protection initiative. Debtors have been charged of operating their businesses opaquely. According to lawyer David Finger, who is defending Bloomberg LP, Dow Jones & Company, the New York Times, and the Financial Times, that mentality appears to have spilled over to this bankruptcy. According to the media businesses, FTX is attempting to conceal information that traditionally has been quintessentially public in nature. The trustee and media companies contend that the identities must be made public even though they haven't objected to the trustee withholding the addresses and phone numbers of consumers and creditors who are specific people. They dispute claims that the GDPR forbids FTX from disclosing specific information, asserting that it does not replace U.S. bankruptcy law. In a court filing last week, Finger said that the court should not treat foreign citizens differently than the United States residents implicated in this matter. Sarkessian, meantime, remarked that given that some customers' only means of communication is an email address, FTX has not specified how it will identify which clients are residents of the EU or the UK. FTX lawyers also asked the court for permission to sell two connected debtor holding companies, FTX Japan Holdings and FTX Europe AG, as well as two non-debtor companies, Embed Financial Technologies Incorporated and LedgerX LLC, on Thursday. Each of the newly acquired companies, according to FTX, has been subject to severe customer and personnel attrition pressures, and selling them might enable them to continue or resume operations while maximizing the value of the bankruptcy estate.